That Roe is dead opens more questions than it answers. What happens next after the Dobbs decision? Well, today we're going to look at some of the most pressing issues, from trigger laws to abortion pills to federal codification of Roe. And we start with the idea of whether states can criminalize abortion. The answer here is obviously yes, they can now. The Supreme Court ruled that states have the right to regulate abortion because abortion laws now are subject to rational basis review, which means that as long as they have any rational reason for passing a law, it will pass. And that means that states can now criminalize abortions. Before Roe versus Wade, 2/3 of states outlawed abortion, with some making it a criminal offense. The majority opinion in Dobbs says that women do not have a fundamental right to privacy when it comes to abortions, and therefore the opinion took no official stance on whether it was okay for states to prosecute women, abortion service providers, or people who help women obtain an abortion. That will be left up to the state, and the states will be able to criminalize that if they so desire. And obviously, looking state by state, the situation in many states is in flux. There are 27 states where abortion is protected and are likely to stay that way. Abortion protective states are passing laws to create safe havens for people who travel from out of state. Connecticut passed a law saying that its agencies will not participate in any investigations, lawsuits, prosecutions, or anything related to abortions performed in Connecticut. The state residents will also be allowed to countersue if they are sued for offering help to abortion patients in another state. This is in response to the Texas bounty hunter law. And New York, Illinois, and California are debating similar efforts. Of course, once states begin denying each other's citizens certain rights, this invites more conflict for the courts to decide. What about comity between the states? These interstate conflicts could redefine how much sovereignty states have in this federalist system. And then there are the trigger laws. 13 states had trigger laws on the books that banned abortion as soon as Roe and Casey were overturned. These 13 states with trigger laws had exceptions to save the life of the pregnant woman, but only 5 of these states have exceptions for rape or incest. And if someone becomes pregnant by a male relative in Arkansas, Kentucky, Louisiana, Missouri, North and South Dakota, Tennessee, Texas, or Mississippi, they will be forced to give birth. And if someone is raped in those states, they will also be forced to give birth.
I just have never believed that having a tragedy or a tragic situation happen to someone is a reason to have another tragedy occur.
So
I
no
would
exception
prefer that we
for rape or
continue to
incest.
make sure we go forward.
There are 5 states, including Texas, where abortion is banned, and there are 8 states where abortion will soon be banned. And there are, of course, a huge variety of different pro-choice and anti-abortion laws throughout the country. Different states have different cutoffs. Some are based on viability, others on a number of weeks. Some allow exceptions for rape and incest, and some do not, and it's only going to get more complicated as states rush to ban or allow abortion. But what about the fetal heartbeat bills? Until the Dobbs ruling, federal courts had unanimously struck down the so-called heartbeat bills, outlawing abortion after the detection of a fetal heartbeat. And that's why states like Ohio, Georgia, South Carolina, and Iowa passed trigger laws with 6-week abortion bans. Legislatures did not repeal those laws, and abortion is banned after the 6th week of pregnancy in those states. The Supreme Court decision did not say that the states had to allow abortion until week 6, so any of those states are free to pass total bans if they desire, though the Georgia law is currently enjoined by the court. And then, of course, much has been said about potential religious exceptions. Many states have laws on the books that allow pharmacists to refuse to fill prescriptions if they have moral or religious objections. And with the Supreme Court's ever-increasing deference to individual religious liberties, we may see more pharmacists and medical providers claiming a right not to fill prescriptions for abortion medication or participate in services like surgery to remove an ectopic pregnancy. And it's unclear how those cases would be treated. It's similarly unclear how the court would treat a claim of religious liberty claiming that, based on certain religious beliefs, abortion is mandated in certain circumstances, even in a state that outlaws abortion. Who knows how the court is going to come down on that. But it's also possible continued jurisprudence from this Supreme Court could answer all of these questions in the negative and simply outlaw abortion. Constitutional rights currently only attach to people who are already born. The debate in Roe, Casey, and Dobbs was over balancing a woman's right to the state's interest. But anti-abortion activists argue that individual rights should attach to embryos and fetus, sometimes at the point of conception, putting them on equal legal grounds as a born human being. Now, the theory that unborn lives or potential life are included in the constitutional concept of persons is not particularly developed, and the unborn have never been counted in the US Census, for example. They've also never been treated as persons for purposes of constitutional rights. However, Justice Alito left the door open to fetal personhood in the Dobbs opinion. In Roe versus Wade, the court said that the unborn have never been recognized in law as persons in the whole sense. The Casey court said that a woman has a right to an abortion up until the point in which the fetus could be viable and live outside outside the mother. And even after that point, there are medical situations where women would need an abortion to save her life, and that would be allowed. But in the Dobbs opinion, Justice Alito declined to say exactly when rights should attach to potential life. But he criticized Roe and Casey for attempting to draw that line. However, Alito himself used the same terminology that was used in Roe and Casey, that of potential human life, without agreeing with it, which is often a linguistic trick that signals that he actually disagrees with that conception of it. This Supreme Court is already treading new ground with respect to what qualifies as deeply rooted within the history of the United States or necessary for an ordered liberty, and is it entirely possible that they might find that liberty interests or personhood attaches to potential or unborn life. 6 states already have introduced fetal personhood legislation in 2022, and the situation in Arizona gives us a pretty good idea of how complicated this issue may become. The state enacted a 15-week abortion ban, but that was before the Dobbs opinion made it legal to ban all abortions. Arizona simultaneously enacted a policy that gives potential life to full personhood. The state's interpretation policy states the following, quote, "The laws of the state shall be interpreted and construed to acknowledge on behalf of an unborn child at every stage of development all rights, privileges, and immunities available to other persons, citizens, and residents of the state, subject only to the Constitution of the United States and decisions interpreting thereof by the United States Supreme Court." This interpretation policy incorporates the statutory definition of unborn child set forth in Arizona law, which provides that an unborn child is, quote, "the offspring of human beings from conception until birth." As written, the law could impact a woman throughout her pregnancy, giving the state the ability to regulate how she handles basically every aspect of that pregnancy. And as written, it could encompass fertilized eggs, which would have the same status as a born human being, triggering limitations on abortion medications and even IVF. The ACLU of Arizona and the Center for Reproductive Rights sued to block implementation of this law, and the court is scheduled to have a hearing on this lawsuit in July. But if the Supreme Court adopted such a definition as being mandated by the Constitution, it would presumably prevent all abortions in all 50 states. And that brings us to the potential national provision of abortion pills through the mail. Now, over half of all abortions in the United States are done with medication, which means that they are induced by pills. In 2021, the Food and Drug Administration, the FDA, decided to allow abortion pills, giving providers the green light to distribute them by mail. The medication, which is used during the first 10 weeks of pregnancy, is a 2-drug regimen. And the FDA removed a prior guideline requiring the person to meet personally with a licensed physician. 19 states banned the administration of an abortion pill by a telehealth provider, even if that person is a licensed physician. GenBioPro, the manufacturer of the generic drug, sued the state of Mississippi back in May after the state passed a law saying that only a state licensed physician could prescribe the medication in person. The state also requires women to take the pills in the presence of a physician. Now, the pharmaceutical company contends that the FDA's regulations for dispensing and prescribing the pill preempt the state's requirements, and generally a federal agency's regulations have supremacy over state law. However, this is another area where the Supreme Court is reevaluating. This Supreme Court is currently scaling back regulatory authority and reinvigorating the non-delegation doctrine, all of which could have significant effects on what the FDA can and cannot regulate. And a state is likely to defend such lawsuits by arguing that Congress did not give the FDA explicit authority to regulate abortion pills, and thus there's nothing to override state laws. And then there's interstate travel. Will women be able to travel to another state to get an abortion? Well, Justice Kavanaugh wrote in his concurring opinion that a state cannot ban women from traveling from one state to another to get an abortion. He called that an easy question to answer. However, that issue wasn't before the court in the Dobbs case, and his opinion doesn't have any legal weight. So is he right? Well, there's actually not a lot of case law on the right to travel between states. During the Dust Bowl years, California tried to ban immigration of people from Oklahoma. At the time, California asserted that mass migration of indigent people stressed the state's budget and created a crisis of health and morals. The states generally have broad police power to regulate health, safety, welfare, and morals of its citizens, but the Supreme Court struck down the law on the basis that it was not a valid exercise of the police power of California and that it imposes an unconstitutional burden upon interstate commerce. In addition to the Commerce Clause, people might look to the Privileges and Immunities Clause, which protects the rights of U.S. citizens against discriminatory treatment under the law of a different state. And in a 1985 case called the Supreme Court of New Hampshire versus Piper, the U.S. Supreme Court held that a New Hampshire rule that limited bar admission to state residents violated the Privileges and Immunities Clause. In 1999, the court decided another privileges and immunities case, Sines versus Roe. In that case, the court said that the right to interstate travel consists of 3 components. 1, the right to enter and leave another state. 2, the right to be treated as a welcome visitor when temporarily present in another state. And 3, the right to be treated like other citizens of that state for those travelers who elect to become permanent residents. These cases generally say that people have a constitutional right to move freely between states. But states are asserting new powers over their residents. We've covered the Senate Bill 8, the Texas bounty hunter law that allows citizens to sue anyone who assists someone in obtaining an abortion. And since the Supreme Court didn't strike that law down, other states were inspired to draft similar laws. In Missouri, lawmakers are debating a law that would allow the state to criminally prosecute anyone who aids someone in getting an abortion in Missouri, but also if they help the person travel to a state where the abortion is legal. And obviously there are all sorts of problems underlying these proposed laws because it purports to make a criminal conspiracy out of conduct that occurs wholly in another state where Missouri has no jurisdiction. And the Missouri legislators who are drafting the bill also want to create civil liability for anyone in the chain who helps a Missouri resident get an abortion, including people who do the marketing of an out-of-state abortion clinic. Though the Supreme Court has weighed in on a similar situation before. In 1975, the court reversed the conviction of a Virginia editor whose newspaper advertised reproductive health services offered in New York. The court said, quote, "A state does not acquire the power or supervision over the internal affairs of another state merely because the welfare and health of its own citizens may be affected when they travel to that state." Now, states that are protective of reproductive rights, like California and Massachusetts, are also passing laws welcoming non-residents who want abortion services and shielding their own citizens from prosecution and civil liability. For example, a Massachusetts law exempts in-state healthcare providers from liability for providing services to abortion seekers from out of state. The law prohibits the state from extraditing anyone to a state that outlaws abortion and protects people from having their medical records disclosed to states that have criminal penalties for abortion. But just because the Supreme Court weighed in on a similar question 45 years ago doesn't mean that the current Supreme Court is going to have the same outcome, especially where we're going to have even more of a patchwork of different laws, some of which are trying to create criminal guilt and some of which are trying to prevent it. And then, of course, there is the First Amendment. Since abortion will be a crime in several states, some anti-abortion advocates are already suggesting that states outlaw any speech that provides information that might be used to terminate a pregnancy or encourages an illegal abortion. And there are a million thorny questions like this that are going to come up, and it's unknown how the courts are going to treat these cases. And then there is the District of Columbia. Washington, D.C. is not a state. So now that the court has sent abortion back to the states, what does that mean for D.C. residents? Well, Washington, D.C. is a federal district with limited self-governance under the 1973 Home Rule Act. However, under the Constitution, Congress is the ultimate authority over Washington, D.C. So it's likely that the current Democratic Congress is not going to do anything to restrict abortion in D.C., where it remains legal today. However, a Republican Congress might want to end that. In fact, Representative Andrew Clyde, a Republican from Georgia, said his top focus will now be, quote, ending D.C.'s failed experiment of home rule once and for all. If Republicans retake congressional majorities later this year, they might decide to criminalize abortion in D.C. And that takes us to congressional action. There are two questions before Congress. The first is, could a Republican Congress impose a national ban on abortion if they take power? Well, in Dobbs, the Supreme Court implied that there was no due process right to an abortion. That leaves decisions up to the state. But we live in a federal system with a supremacy clause. So could Congress pass a national law that banned abortion everywhere in the United States? Well, a majority of the court probably does not think the national abortion ban would be unconstitutional. In other words, they could probably get away with it. If Congress enacted a national ban, Congress could cite their power to regulate interstate commerce under the Commerce Clause, which is often how many different laws are passed. But that would be pretty easy to do. Congress could write a law that says abortions can't be performed if they use any device which traveled in interstate commerce, or using any medication containing any component which has traveled in interstate commerce, or simply that people being born implicates commerce because they're going to engage in commerce when they get older, or their parents engage in commerce as part of the process. Although many of the court's conservative justices have been skeptical of the government's commerce power, this situation could be different if what's being regulated is abortion. Justice Roberts is the only conservative justice on the court who has supported a federal government's broad right to regulate interstate commerce, so his fellow justices could wind up lobbying him to uphold a ban. They could also invoke Section 5 of the 14th Amendment, the Due Process Clause. This, of course, is the same clause that women once relied on for the right to abortion, but Congress could pass a law stating that fetuses are people under the 14th Amendment and that they have a right to life under that section. The second question is, could a Democratic Congress pass a nationwide pro-abortion law, making abortion legal in 50 states? Well, if Congress enacted a law codifying the right to an abortion nationwide, what would happen? Again, that would depend on the way that the law is written and whether the court would interpret the commerce power to encompass such a law. But here, I would be more skeptical. The Supreme Court could take a narrow interpretation of the commerce power, as we just talked about, and it's entirely possible that this court is so outcome-driven that it would allow commerce power for a ban on abortion, but would not allow commerce power for a nationwide right to abortion. But you can't know until you try. Congress could also state that women have a due process liberty interest to an abortion. That would be advisory to the Supreme Court. They would be the ultimate arbiters, but that would put the ball back with the Supreme Court again. We can guess how this Supreme Court might find on that particular theory, but again, we don't know. And then there is the question of all of the other rights that are implicated by substantive due process. Could the Supreme Court start rolling back a lot of the rights that we've come to presume over the last 50 years? And the answer is very possibly those rights have a target on their back. Contraception, interracial marriage, intimate sexual acts, same-sex marriage, all stem from a common judicial doctrine known as substantive due process. Texas Attorney General Ken Paxton says he wants to start enforcing the state's antiquated sodomy laws, which are unconstitutional under the current Supreme Court jurisprudence. But Justice Thomas explicitly says that we should do away with all substantive due process rights. Justice Kavanaugh says that Dobbs should have zero effect on other rights that originate in substantive due process. But the majority in Dobbs suggests that abortion is different because it implicates potential life. But also, the court engaged in a deeply rooted analysis that only looks to history, and it's hard to see how any of those other rights would survive using the same analysis that the court engaged in Dobbs. And the dissent in Dobbs made this crystal clear, quote, "And no one should be confident that this majority is done with its work. The right Roe and Casey recognized does not stand alone. To the contrary, the court has linked it for decades to other settled freedoms involving bodily integrity, familial relationships, and procreation. Most obviously, the right to terminate a pregnancy arose out of the right to purchase and use contraception. In turn, those rights led more recently to rights of same-sex intimacy and marriage. They are all part of the same constitutional fabric, protecting autonomous decision-making over the most personal of life decisions. The majority, or to be more accurate, most of it, is eager to tell us today that nothing it does casts doubt on the precedents that do not concern abortion. But how could that be? The lone rationale for what the majority does today is that the right to elect an abortion is not deeply rooted in history. Not until Roe, the majority argues, did people think abortion fell within the Constitution's guarantee of liberty. The same could be said, though, of most of the rights the majority claims it is not tampering with. The majority could write just as long an opinion showing, for example, that until the mid-20th century, there was no support in American law for a constitutional right to obtain contraceptives. So one of two things must be true. Either the majority does not really believe in its own reasoning, or if it does, all rights that have no history stretching back to the mid-19th century are insecure. Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under threat. It is one or the other. So don't be surprised if this Supreme Court starts rolling back these freedoms and rights, and it would probably start with same-sex marriage. And all of that is why there are a lot of reproductive health charities out there that are going to need some help. And one very small way that I like to do so is a company that I work with called Tab for a Cause, which lets you raise money for charity just by opening up tabs and browsing the internet. And that includes reproductive rights charities, because they just launched Tab for Reproductive Health, because of all of this. And that lets you raise money for nonprofit organizations protecting and providing access to reproductive health care, like the Center for Reproductive Rights and Planned Parenthood. And I know this is just a little thing, but it's something that you can do right now from the comfort of your own home. The way it works is that Tab for Cause is a browser extension that allows you to pick the charity of your choice. And then every time you open up a new tab, instead of displaying a blank page, it displays a customizable tab with a couple of tiny ads. And the money that you generate is then given to the charity that you choose. You can see in real time how much money is being generated, and you can even customize this tab in the way that you would like it. And LegalEagle tabbers have raised over $35,000 alone, and I know this because Tab for Cause's finances are 100% transparent, so you can see for yourself how much they've raised and where it's gone. So if that sounds interesting to you, if you'd like to make a small difference together, all you have to do is click on the link that's on screen right now or in the description to install the browser extension, and then that's it. Then every page that you open will create revenue that goes to charity, in this case, reproductive health charities. So all you have to do is click on the link that's on screen, or feel free not to as well. And until next time, I will see you in court.